on this slide is on the first page of your chapter. It gives you an idea of what we're going to cover. I would say a few things kind of introducing this course. One is you don't have to know Latin unless I tell you. So, which I think is kind of ironic. My son, who is in the 4th grade, has to take Latin. So I'm teaching him Latin. But I, who went through high school, college, and law school, never had to take Latin. I just think I laugh at him about it, but anyway. So occasionally as we go through the class, I'll say, and here's a term you need to know. And you go, right? So, and the other thing is, you don't have to remember years or specific statute numbers or case names. I'm not trying to get you to be lawyers and memorize all that stuff. In fact, I don't have it all memorized. The student in class said, well, what about the case of blah, blah, blah? I'm like, what's that? I sometimes need to go look stuff up because I don't necessarily remember all the case names and what they stand for. So, like in the chapter talking about the Norman Conquest of 1066, I'm not going to ask you what year the Norman Conquest of 1066 is.
What will you ask them?
Not that. I will try to focus on the major concepts of law in that area. Now, sometimes students and I differ about that, what you might consider nitpicky or some small detail. I really do try to hit on the major things in class, but I also do expect that you've read what I've asked you to read. And then when you go to take a quiz or do the essays, that you should look at the resources that I give you. So if a student says, well, you didn't say that in class, this is not about me just spouting off things and then you writing down whatever I say and then, spitting it back to me. It kind of reminds me of this weekend. I tell you, my son was projectile vomiting. And I got a call today. Another one's doing it. So, front row. All right. So, and some other things. A lot of students think the law is black and white. It's not. If you've had experience with it, you know that. Where do you get most of the things you know or think you know about the law? TV. Usually it takes a little while to get that out of people. They hate to admit it, but no one sat you down at a young age and explained statutory law to you, right? Well, maybe some things came up, but generally this is just something you pick up from what you've heard. It's rarely black and white, and in fact, in a given business transaction, multiple areas of the law might apply. It's like a simple contract action. If there's a breach of contract, it might involve somebody defaming the business, saying something bad about the business. It might involve contract law. And we're not going to spend a lot of time in ethics. I'll try to make connections between the two. I will say that law is supposed to reflect our ethics, our values, what we believe to be morally correct, but I bet I could say most of you could think of a law that you don't agree with, right? It doesn't necessarily reflect all of our standards or beliefs. Somebody in the last class is like, speeding, I don't get it, Why is there a law about that? I kind of agree with them, but it's not a moral issue, really. I mean, no one said 70 because it's immoral to go faster. They just all got together and say, well, how fast can they go before they kill each other? Let's make it 70. And then, there's all kinds of other statutes. Like one of the most recent ones I heard was a distracted driving statute. I may have got it wrong. I'm listening to NPR, kind of. I try not to listen directly to NPR. It might influence me, so I kind of listen off to the side. And it was talking about Troy, Michigan, I think, and how they have this distracted driving statute. And if you're drinking coffee and it distracts you, you can get pulled over and ticketed for it, which I drink a lot of coffee, so I better not go there. But anyway, not necessarily a moral issue, but interest of public safety, I guess. I don't know, what do you guys think? Should you be able to talk on the cell phone while you're driving?
No.
I don't think you should be able to walk down these halls with a cell phone. You guys ever watch yourselves, man? I'm coming up behind you. You're weaving. You're weaving all over the place. I go to the right. You veer off to the right. It's crazy. You're coming at me. It's like a head-on collision. You know they make an app now where you can text and see whoever's in front of you? I guess you'd have to hold the phone up like this, though. What's that? It's an app that uses your camera to show you on your screen what's in front of you. So you have to text like this, which is, I don't know, it's weird. I don't know. It could save a life, though. All right. So here are the major sources of law. The first is constitutional, kind of a no-brainer, comes from the Constitution, right? There's a U.S. federal Constitution. I'll use those terms interchangeably. And notice the second bullet. U.S. Constitution is supreme law of the land. Don't let that be a trick to you. Sometime in the future, on a quiz or a final exam, I'll say, the Supreme Court says this. The U.S. Constitution says that. Who wins? And you'll go, supreme. That sounds supreme. Right? But where does the Supreme Court get its jurisdiction from? The Constitution. So, in the end, somebody will say, but wait a second. Is there a well actually in here? Who's the guy that'll say well actually all the time? Yeah, I'll find you. But, well actually the Supreme Court interprets the Constitution. That's true. Very powerful. And then they have times have even overturned themselves and said, well, we were wrong about what we thought about the Constitution. And then there are state constitutions. So technically, if you feel your constitutional rights are violated, you might have a Michigan claim as well as a U.S. constitutional claim. Now, why would, if you just feel your rights were violated, would you want to bring both a state and federal claim, or pick one or the other? It might depend on which court you want to be in, right? Nothing? Okay. Well, we'll come back to that in a little while. I'll give you an example. When I was in law school, I worked for the Department of Corrections. And because I was just clerking there, I would get all the prisoner letters, lawsuits. And I won't tell you everything I found when I opened the letters, but one of the things they would claim is that the state violated their U.S. constitutional rights, and they wanted to go to federal court. Now, why do you think they would want to go to federal court when they're in a state correctional facility? That's right. Good. You think like a prisoner. I mean, doesn't that make sense that a state you feel did you wrong, if you go to their courts, they're going to side with the state, not with you. So they were kind of paranoid about that. What do you think another thing might be? I suppose. But often it was because they felt they could get treated better or more preferential in a federal court. So they didn't like the state, and then they thought maybe in the federal system they'd get better remedies, or the judge would be more favorable to them. And that was actually the case, because at the time there were two judges who handled those cases. One was Judge Enslin, who was very against the Department of Corrections. And so anytime a prisoner said something happened, he'd say, it must have happened. And then the other one was Judge Bell. Anybody know who Robert Holmes Bell is? Anybody know who Rob Bell is? Yeah, it's his dad. Anyway, he was very conservative, like toting a gun under the bench type guy. So he didn't want to go in front of him. All right, anyway. Statutory law. Statutory law comes from statutes. Statutes come from the legislature. So, again, at a federal level in Congress or at a state legislative level, they create statutory law Even at a local level, like a local ordinance. Anybody ever dealt with local ordinances? Like?
I remember I was actually really young, but my mom still gave me help. Where we live, we have almost like a wetland behind us,
Mm-hmm.
and the developer decided he wanted to put 22, like the bigger houses in there, little half acres of land, so your house took up almost your entire plot.
Mm-hmm.
We wanted to completely destroy everything that was back there. So we went. I remember my mom gave me all this stuff. I had like this little note card with all the stuff on it written down, and I had to go knock on people's door and get signatures.
Oh, wow. Well, that's cool, getting involved at an early age. It was awful. I wouldn't do it, but...
Build there now, and houses that were put there in the early 80s actually now been bought out by, I guess, the township, and not now.
Oh, okay. Others experience with ordinances? Noise ordinances? Zoning? My most recent one was my pool. I started out with a kiddie pool, and then it just kept getting bigger and bigger every year. And then finally, last year, well, actually the year before last, my wife calls me. She says, the zoning enforcers were just here. I said, oh, yeah, what do they want? They measured our pool, and they said it's not in compliance with the zoning ordinance. And we either have to take it down and leave it down or put up a new one that meets the ordinance. So I got home, and then I found out that I had to pull a building permit to put it in. This is Georgetown Township, so if anybody lives there, and go and hire an electrician and all that. So I just tore the pool down, and all the kids cried the rest of the summer, but it was a nice bare spot for them to play in.
Do you have homeowners association?
No.
No? Okay, I was going to say.
No, I should know.
Okay.
Come on. I should know that there's an ordinance. And I did, and actually I swear when I put the pool up, it was tall enough. I think it shrunk. No, I think it's settled. Like the guys out there, you're like, it's just under. But you have to actually do a site plan, pay for the permit, have the code enforcers come out and inspect it, and then hire an electrician to put all the stuff in and have them inspected again. So I did that this past summer. So lots of things could affect you if you're dealing with ordinances. And then finally, the Uniform Commercial Code or other uniform laws, trying to make it the law uniform in terms of statutes across several states, because it's not always the same. You know, I think of speeding. Ever been speeding? No, I know you guys would never speed, but you may go on one speed in one state and you can get in a different state?
Yeah.
Then it changes?
Texas.
Yeah? Got a ticket for it?
No, my dad did.
Yeah?
He was in Wisconsin, and he didn't even have a radar gun, but he's like, oh, I eyeballed you at 70.
Eyeballed you?
Yeah.
Awesome.
So, and my parents are in Wisconsin, they don't want to go back and fight it.
Right.
But they
Oh,
have
yeah.
to.
Right. Yeah.
Because
Big source of revenue.
It was going to be like,
Stop everybody who doesn't have a Wisconsin license plate on and give them a ticket.
yeah.
Say, I eyeballed you.
Yeah. He didn't even have proof, and my mom and Amic were both in the car. And
Uh-huh. Yeah.
It was like a $127 ticket.
Oh.
Yeah.
Ooh.
Yeah.
Not good.
Yeah.
Let's boycott Wisconsin.
Yeah.
Nothing good came out of there. Okay. Wow, it's like a cheese revolt all at the same time. Note, this class likes cheese. All right, administrative law. So a lot of people think of the Constitution, they think of the legislature, but really administrative law is a big body of law. There are lots of administrative agencies out there. Anything that ends in CC, TC, DA, you know, if you think about it, it mentions the FDA up there. They have the ability to make their own rules, to enforce them, and then punish people who violate them. So they can have hearings on laws that they created and then impose fines or other things on people. So it's really, you know, if you kind of remember the whole balance of power thing, it seems like they got a lot of power. They could get their funding taken away, or they could get changed. You know, every time there's a big shakeup in the United States, an administrative agency ends up getting renamed or reorganized or whatever. I was listening to NPR again this morning, and they were talking about how some airports are now hiring private security because they think TSA isn't any good. So that one's interesting. Anybody love the TSA? Don't have anything against them. All right. And then the last major source of American law, which is the biggest body of law that we have, is the common law. Another word for the common law that's not up there is case law. So if it's called case law, where does it come from? Cases, which come from courts, right? So this is the court-made law, judge-made law. This is a judicial branch making law through deciding cases. Right? So whenever I said, where's the common law come from? People spout back, England. Okay. It's not exactly what I'm looking for, but yes, that's true. It's so old that we got it from somewhere else, and we still have this system. And a number of concepts did come from England, like the last bullet there says precedent, not president. But precedent, the idea that once you decide a case, that in the future, if you come across a similar case, you should decide it the same way. And over time, you have a body of law about the same type of issue. And that developed into this term that you do have to know, stare decisis, which means stand undecided cases or something like that. Basically, the idea that in order for the courts to be fair and efficient, once they decide a case, they should decide it the same way, unless there's some compelling reason not to, in the future. If you go in there, they shouldn't say, we're in a bad mood today, you lose, you're ugly, you lose. They should say, this is the kind of case you have, this is how we've decided before, we're going to stand on the way we decided it before. And the idea of binding authority. Anybody have a boss that tells them what to do? Okay. So one day your boss tells you what to do, then the next day you go in, kind of do things your own way. What's probably going to happen? Might get in trouble, might get fired, reprimanded, whatever. Same thing in the court system. The higher court in your court system establishes precedent, then you need to follow it. You don't come in and make your own law one day and say, well, we know what you've decided, but we're going to be different. Eventually, after cases coming back to you on appeal, somebody's going to talk to you about it. Now, it says at the bottom there that this helps the court stay efficient. I don't usually use court and efficient together in the same sentence, but I guess more efficient than it would be if we didn't have this idea of being consistent. And basically the idea is cases get reported in books, not all of them, but important ones. And then when somebody needs to decide something, instead of reinventing the wheel and deciding everything over from scratch, like they've never heard it before, they go, oh yeah, that sounds familiar. And they go look up that type of case and try to find it. All right. Now, remedies. So you go to court and you complain. You don't complain just because it's therapeutic. You do it because you want the court to do something about it. You want to be in the right court that has the power to do something about it, but in the end, you need a remedy. You need a fix to your situation. You want to be made whole. And I don't know, this is about page 10 where it's talking about remedies. I think this 9. This diagram, what page is that on? 9? 10? Okay, yeah. So page 9 and 10, we'll say. And this exhibit, which talks about actions in law and actions in equity. So I'll get back to that in a minute. But basically, there's two divisions here. When we talk about a remedy at law, we're talking about money damages usually. A lot of people, when they think of a lawsuit, they think of money damages. How much can I get for what the other person did to me? But money is not always going to do it. Sometimes money won't fix the problem. Then there's equitable remedies. Now, when I say equity to a bunch of business students, which I know you're not all business students, but when I think equity, you say, yeah, house, accounting, stock, ownership, those type of things. But equity here means what? Doing what's equitable, what's fair. That's what we're talking about when we talk about equity in the law. And so getting money for something and getting what's fair are not always the same thing. So I'll give you an example. When I first started teaching here, I lived in Kalamazoo. 5 years of driving up and down 131, especially in the snow. Not fun if anyone's done that. And finally I thought, why am I driving? Why don't I move up here? I'm slow. So we started looking for a house. Anybody own a house or rent a house or ever looked for some place to live? Yeah. So what kind of things do you look for? School? Price? Location? Near where you work? Anything else? How far from clowns? Sorry, now I feel bad, like you'll never be able to. What else? Right. What's the future looking like? Is there, like we were looking at, will they develop behind our house? Is the highway coming through here? So we looked around, and then after all that, I had my list. Price at the top for me, because I'm a practical guy, and then all these other factors. And then we'd go into a house, and then there was my wife. And it had to be a home. Apparently there's some difference between a house and a home, right? And she had to come in and go, yes, this is it. And then change everything. But anyway, so we looked around, and finally we walked through a door. I'm like, check, yep. And she smiles and says, yes, this is it. This is our home. And if you don't get it for me, you're not a man. No, she didn't say that, but it sure felt that way, right? So I'm like plunking the check down. We're selling our house in Kalamazoo, putting stuff in storage, moving up here, getting ready for the closing. We get to the closing, and the sellers say, we've decided not to sell. After all of that. So if we had taken them to court, and we go all the way through a trial, and the end, the judge says, here's your money back. How much money would that be? How much would we get? What we put down, we should get it back. It's not theirs. They're backing out of the deal. What else? Storage, expenses related to the closing, arguing that I had to miss work, whatever. So let's say the judge is generous and gives me all of that. Now what am I going to do with the money? Yep, start looking for a house. And how many houses are exactly like this house? None, zero. Even if you found the identical house, it wouldn't be on the same piece of property. So sometimes the fair thing to do is for the court to make the other party do what they already promised to do. I made it all up. It didn't happen. But if any of this had happened, then I don't want the money, right? I want them to do what they already promised to do. I want the house. Now, notice that the reason, like later I'll be like, why did I tell that story? Because you're a fat liar. No, that's not why I told this story. I told this story because I want you to remember that sometimes you get an equitable remedy because there's no other fair remedy. The house is unique. Like what if it was for a TV? I could go all the way to the store and I look at a TV and I get all excited about it and I buy it and then they come out of the back room and they go, we don't have it. Do I sue them and try to get an equitable remedy to get that TV? What's the court? Okay. That's a later chapter. Don't be bringing that up. Yeah. I mean, it might be. It might be, yeah, we've got it, and then later saying we don't have it, pay more, right? But I could just take my money and go find the same TV somewhere else. I mean, it's not that TV, but it's the same thing, right? I mean, it's the same model, etc. You know, I don't know, I think they're listening to me, because every once in a while, when I give a great example like a TV, they clap. I don't know. So, that's specific performance. When the court makes the other party specifically perform what they already promised to do. And you only get it in certain situations, usually when whatever the subject is unique. Then there's injunction and rescission. I think these are in the lower right-hand corner of that exhibit. An injunction is an order telling somebody to stop doing something. Like with the wetlands example. It's one thing to say, slap somebody's patties and say you're fined for doing something to wetlands, but you also want them to stop doing that. Right. Yeah. Yeah. While we were building our house, we built our house because we couldn't find anything that she was happy with. She never listens to these recordings, so I can say whatever I want. But we were living in some townhouses up behind the Rivertown Crossing Mall, which was built on wetlands. So I can relate to what you're talking about. Anyway, so a rescission is the court undoing a contract. So instead of my example where the court enforces an existing promise, the court says you get to get out of it. Now, in my situation that I made up about us making the other party sell us the house, what might be a reason that I want a court to undo the contract? What's that? Yeah, that's a tough one. Especially in this economy, going in and saying I lost my job, can't afford what I agreed to pay for. Usually not. Right, so let's say they say something that's fraudulent misrepresentation. Oh yeah, it's a good house, it's never been damaged, and it turns out that it has been.
But isn't that why you get a contractor to go look at it before?
Yeah, so that's what I'm saying is we have inspections of the house we're going to buy, and the inspection reveals something that they intentionally concealed from me. And should they be able to force me to buy the house, or should I be able to get the court to let me out of the contract if they won't? I should be able to get the court to undo the contract. But yeah, that's why you have it inspected, so you know about that beforehand. Plaintiff is the party who's allegedly injured and suing, and the defendant's the one who allegedly caused the injury. Now, when I use the term injury, I don't mean like physical, although it could be. I mean broader. Could be economic injury, emotional, physical, something that causes the plaintiff a loss. And so here those remedies are side by side, and you can kind of see some of the other differences. For example, if you sue somebody for a legal remedy, a judge or jury could decide that. But if it's an equitable remedy, you're seeking what's fair, that's usually up to the judge. Presumably because a bunch of jurors can't ever figure out collectively what's fair. And somebody in last class was like, but they can decide my fate as to whether I go to prison or not. Yeah. So, yeah, I mean, if you think about it, the people that are deciding what happens to you as a result of a criminal charge have no experience usually with the law at all. Substantive versus procedural law and civil versus criminal law. So kind of splitting up major bodies of law. I think substantive versus procedural is probably one of the harder ones to understand. I like to think of substantive as your rights. You have rights. What kind of rights do you have that you know about? Some of you are exercising that today. Yes. What else? Always concerns me the student who says that. What else?
Freedom of religion.
Yep. Speech. Okay.
Nonviolent assembly.
Right. Exactly. So we know that we have those things, and most of those you've mentioned come from the Constitution. Right? But what does it mean if we don't actually get them? Like we could have a shirt that says, I have the right to whatever, bear arms. But unless we actually get to do the things that we're supposedly have a right to do, then they don't mean anything. So, for example, we have a right to have an attorney. But let's say we're charged with something, we go to court, the court ignores that we don't have an attorney. When we ask for one, they won't give us one, and they won't let us have one. Well, then procedurally, we haven't got what we're entitled to get, right? Well, speaking of mistrials, I've seen that happen. When I came out of law school, I went to a small prosecutor's office, and it relates to the right you mentioned, remain silent. I was watching a city attorney try a case, and in the case, in front of a jury, the city attorney says, I now call the defendant to the stand. So most people think of the substantive right to not incriminate oneself and to remain silent as a constitutional right, but maybe they don't think about it in that context. What does it mean to the defendant when the prosecutor makes them take the stand in front of the jury? Like, if you're a defendant, shouldn't you choose whether you get up on the stand or not? Now what's it look like if you're in front of a jury and the prosecutor invites you to get up on the stand and tell your side of the story, defend yourself, which is not the way the burden of proof is supposed to work, and you go, no? Now what's it look like? Right. Well, why aren't you explaining yourself, right? You must be guilty. You know, there's this presumption that you're innocent until proven guilty. You're shaking your head. Most people inside of their head think the opposite. I got to say, from questioning lots of people about this, well, the person would not have been charged if they hadn't done something wrong, and therefore they should defend themselves. I mean, don't you kind of think that, like, this whole presumption of innocence, they must be innocent unless the prosecutor can prove them guilty? So quite a number of people on juries have issue with that. They kind of think, well, something must have happened, so they should really explain why they didn't do it. It's not their job to explain why they didn't do it. It's the prosecution's job to explain why they did do it. Now, you know, this is coming from somebody who's been a prosecutor for years, so. And I'd walk around the courthouse and I would hear what juries were using to decide cases. It was exactly what the judge just told them not to do. Like, don't consider that evidence, and they're back there talking about it. Or, please don't, have biases toward witnesses in ways that, isn't shown through the evidence. They'd be back there, I don't know, he looked kind of shifty to me. I don't like that shirt he's wearing. I mean, like, whoa, can't believe it. And then they'd come out and they'd go, we find the defendant guilty. And I'd be like, yahoo! And then they say, blah, blah, blah. Like, whoa, they weren't even charged with that. Like, they just kind of come up with their own thing. So, anyway. So procedurally, getting those rights that you're entitled to. Civil versus criminal law. I think most people understand that. There are different burdens of proof. This one's not on the slide. You might want to write it down. The burden of proof in a civil case is called a preponderance of the evidence, which means more likely than not. If you sue somebody civilly, you have to establish it's more likely than not that your version is correct, which is a lower burden of proof than in a criminal case. What's it in a criminal case? You ever heard that on a TV show? Yeah, beyond a reasonable doubt. Which means what? I don't know, you only heard it on TV. What's that? Yeah. I've done this, let's see, taught here 10 years, and I teach at least 3 semesters a year, so at least 30 class periods, all go the same. Everything from Well, it means all the evidence points to guilt, to most of it, to more likely than not getting these confused. And, even the court instruction says beyond a reasonable doubt without putting it in terms of all the evidence. I mean, if you think about it, how could you possibly establish that all the evidence points that the defendant did something? That'd be like the defense getting up and go, "You got us. Can't think of anything. You're right. We give up." I haven't seen that happen. So that's one difference. The other big difference between civil and criminal is who the parties are. Remember I talked about plaintiff and defendant a minute ago? In a civil case, it's you versus me. In a criminal case, it's, let's say I slap you. I don't like people who wear glasses and sit in the front row. You're too far away, so bam, I smack you, right? Now, civilly, you'd be the plaintiff. You'd sue me for a tort, for battering you. Right? Knocked your glasses off, broke, you're embarrassed in front of your fellow students. I'm really not going to do that. So, but criminally, I could be arrested. And in that case, I'd still be the defendant, but you're no longer the plaintiff. Who's the plaintiff? The state is, right? You all have an interest in me not slapping her. What is that? No, you're next. Right? Right? Isn't that the idea? Like if I'm running around slapping people, that, you all have an interest in having me punished for that and put it away somewhere or go to anti-slap school or whatever it is to make sure that I don't do that to you, right? Because you're not personally injured by that, but you should not have me running around slapping people. All right.
Can you be tried for both?
Yes. Well, like O.J. Simpson is the most common example of that. O.J. was prosecuted criminally first, and the prosecutor was unable to meet their burden. And then he was sued civilly for civil wrong, a tort of wrongful death, and then they only had to show a preponderance of the evidence.
Because I have a cousin, not related.
Your cousin's O.J.?
No.
Wow.
No,
How's prison going for him?
By marriage, but he gambled away union dues that he was collecting.
Oh, yikes.
Yeah, so he's in big trouble right now.
Yeah.
I think
Yeah.
from that he can be charged for both, right?
Well, I wouldn't touch that with a 10-foot pole. But generally, you could, through one action, violate both a criminal statute and somebody could have a cause of action against you. I mean, it could be multifaceted. It says person works for the government. So now they've violated a criminal statute, embezzlement, or whatever it is. Then they've violated the public trust somehow. And then potentially they took somebody's specific money who has a cause of action against them personally for what they did. I don't know if that's at all what happened, but yeah, all those things could happen. The question is, you said at the same time, typically the criminal action will take priority because there's
tried for criminal
right,
action.
yeah. But the point is also that then that person could then be sued civilly. Because I prosecuted lots of cases, and in the end was successful in the prosecution, but the victim may not have been made whole. Like the court might order restitution, and then here this person is in prison, unable to pay anything, and then some future date the person who their money was stolen sues them civilly and tries to collect the money from them.
They could probably sue the family though, right?
I don't know.
Okay, sorry.
Yeah, I don't know anything about that. But I'm just saying that, well, back to this case, we'd get that all the time. We get in the prosecutor's office, we get businesses coming in and say, so-and-so wrote me a bad check. I want you to prosecute them. Well, there is a criminal statute involving writing bad checks. But it usually, we required them to show some pattern, or like, did you ask for the money? How many times has this happened? Was it intentional? I mean, there's a big difference between some pattern or scheme and somebody who, oops, doesn't intentionally and they bounce a check. What?
So, like, isn't he going to be sued by people and then
Oh yeah, oh yeah,
the government as well?
I'm sure. Yeah, and
This is a Ponzi scheme.
right, and yeah, and
John Bilesman came and spoke on it in business class.
Mhm.
He handled the case for the people that had their money taken.
mhm,
And at this point, from what I understand, he will go to jail for what he did. The government has seized all of his assets.
mhm,
And the people, because he was representing a different stockholder company, that company has agreed with Varnum and another law firm out of Chicago to pay the people back $1 of their investment.
woohoo.
So
Yeah, so sometimes, like when I say,
the initial investment, not what he said their money earned.
right, yeah, in those things, there could be multiple criminal statute violation, private lawsuits, and in the end, people may not be made whole at all. You think back Enron and people that lost their retirement and jobs and all of that. In the end, victims may not be made whole. All right, national versus international law. I think you guys get the difference there. The other thing probably on the slide is civil versus common law, because we were just talking about civil law, but this is different on this slide. We're a common law country because our biggest body of law is case law. When they refer to civil law countries on this, they're talking more of a code-based system. So some countries, and you don't need to memorize a list of which one falls on which side, just have books they open up, look at it, and say, yep, you violated the law. Others are more on a case-by-case basis. All right, constitutional rights. So this is where things should sound pretty familiar if you've had political science or government class before, but I'll try to throw a legal twist on it. So the legislative branch enacts laws. We mentioned statutes. The executive branch enforces the laws, and the judicial branch does more interpretation, more deciding whether what has been done is constitutional or not. And really, the Constitution is kind of a compromise. At the time, back when I was a teenager and they were forming the Constitution, there was a bunch of folks who felt like, we don't like centralized government. We just left that. We want to do our own thing. And then others who were like, well, we're a little insecure. We're not sure we want to be all out on our own. We'd like some centralized government. So the Constitution's set up to give specific powers to centralized government, and then the rest goes to the state. And then those states individually determine what they want to do. I wish it was that simple. I say that, but like anybody following the Asian carp thing? The fish that slap people? Right? So, I'm not into slapping, sorry. I'm intimidating you or something. But, yeah, I mean, the whole now states are probably going to go after each other over that. So we'll talk about the Commerce Clause. Not that important to business, but it is one of the first clauses that we'll talk about. Under Article 1, Section 8, the Constitution gives Congress, the federal government, the power to regulate commerce with foreign nations, among the several states, and with Indian tribes, which has been interpreted to mean other countries, interstate commerce, and casinos. No offense. I think that a lot of discussion lately in terms of Indian tribes has been about casinos. I grew up on Gun Lake, right? So that seems like all they've been talking about for years down there. So, did anybody notice something really crazy I just said, besides casinos and growing up on Gun Lake? No. No, that's in the Constitution. I introduced the slide by saying the Commerce Clause isn't that important to business, but it is in the Constitution, so we will need to talk about it. I don't know if any of you heard me say that. I can prove it. It's on the recording. What does the second bullet say? It has the greatest impact in business than any other constitutional provision. I mean, how can you sit here and listen to me say commerce doesn't really relate to business? Maybe you're in a lunch-induced coma or something right now. Or maybe you're just afraid I'm going to slap you. Whatever it is, if you hear me say something that sounds crazy, you say, whoa, wait, what, really? Commerce Clause isn't important to business? That's not what I read. Maybe you guys haven't read the chapter. Or maybe you trust me. I've already lied to you once. Twice. 3 times. All right. So, yeah, the Commerce Clause is important to business. And we're going to see why. So, in the early interpretation of the Supreme Court of the Commerce Clause, there was this attitude that the Commerce Clause pretty much covered everything because the feds had exclusive power and most things could be related to interstate commerce. Even something that was within a state is bound to affect other states. They weren't thinking about e-commerce back then. There wasn't any internet back then. I know you guys probably don't remember life without the internet, do you? Huh? I remember my first computer. It was huge. It was like a bus. All right. So, for example, Wickard versus Filburn, which is what I'm going to name my next 2 kids. I don't know. Come here, little Wickard and Filburn. I don't know. It just seems like cool names. But in that case, if you read that, I mean, just read that. I mean, this is kind of like the, whoa, stop, that sounds crazy department. Purely local production. A guy grows his own wheat. I have to say that because one class of student got really confused. They're like, I thought growing weed was illegal. But he grows his own wheat, and then he eats it. And then the court says, well, if you ate it, then you took it out of the mouths of interstate commerce. Therefore, the federal government has the ability to regulate even that. I mean, can you think of a more pure a local activity? I mean, short of going to the bathroom, I don't know what else there is besides, growing and eating your own food. Seems pretty local. Right? So, over time, that changed. In 64, anybody know what was going on in 64? It might have been before your time. Right, 64, Civil Rights Act of 64. So in this case, this is a little different. This wasn't an argument that against the Commerce Clause. It was an argument that the Civil Rights Act went too far because it regulated in areas that were reserved for the states. Because this guy said, I'm just renting to locals. I'm not advertising out on the highway. I ought to be able to discriminate against any race I please. And your federal law says I can't do that. Well, even if you guys didn't read the case, what in the title of the case gives you the idea that this deals in interstate commerce? No. Although, yeah, in the end, yes. But motel. I mean, like if you're going to pick a trial case to try this on, are you going to pick a motel and try to argue that that's purely local activity? What are motels for? Yes, for traveling in interstate commerce, right? That's, it's people don't usually stay there because they live next door. They stay there because they've been traveling in interstate commerce and they stop there. So that was a loser. All right. Today, moving forward, theoretically, Constitution hasn't changed. Feds still have the power to control things that are interstate commerce. However, the Supreme Court has done more of a balancing thing. It said that the states can regulate in areas that might impact interstate commerce as long as they don't go too far. So there was a state that passed a law that said trucks coming through our state have to have mud flaps. Exciting case. Are mud flaps a good idea? Sure, they prevent people from getting hit by things, I guess. So when somebody challenged that, they said, well, when we go through that state, we got to put mud flaps on. And the court said, look, the state has a pretty good reason for you to put them on, and just leave them on. It's not a big problem. You won't be in violation of any laws when you go into any other state. So now another state comes along, and they say you have to have round corners on your mud flaps. I don't know why. Maybe so the mud flap doesn't poke somebody in the eye. What do you think the court's going to say about that? Because what would you have to do when you go to that state? Trim off the corners. Yeah, you'd be switching mud flaps, or what's the worst thing that could happen? You go around that state because you don't have the right mud flaps. And is making somebody go around a state in interstate commerce a burden on interstate commerce? Yes. So if it's a ridiculous thing and not a good state interest, then usually they'll side with the feds. Now, sometimes they do a balancing and they say, we're going to let the state do that. Like those huge triple trailer things you see out west. Anybody ever drove up beside one of those things? Scared the crap out of you, right? You don't see a lot of those around here. Why? Because we said we don't want them here. So then the court said, okay, they got a good enough reason. So usually if it's something that has to do with safety and it's a legitimate concern, they'll let it go. Or at least they'll do a balancing test. So 10th Amendment reserved all powers to the state that weren't expressly given to the national government, and that include these inherent police powers, which includes the police, but also include regulating in areas like health, safety, morals, general welfare, those other ordinances that we talked about, like zoning where you can put things. Last class student was talking about a fat tax. That apparently, is it New York? Like apparently some states are passing laws where if you buy food that has certain fats in it, that you get charged a tax on it. California? That makes sense. Those guys are... Right. So that's just weird. I mean, in a way. Or it's not just there. I don't know if I was mentioning it to you guys or I mentioned NPR. I'm listening to NPR again. And they say in Troy, Michigan, they have this distracted driving statute. And they're interviewing a police officer over there. He says, if you're drinking coffee and you have problems while you're driving, you veer or go outside your lane while you drink, we'll pull you over and give you a ticket. I don't know.
So they're not taking the environment into effect? Like, oh, there's a strong wind, I'm distracted.
Well, I mean, I suppose you could say it wasn't the coffee, it was the strong wind. It wasn't that I was texting with my toes, it was the wind shear that just came up. Yeah, I mean, in the end, you could fight it, I suppose, but it was largely around using your cell phone or texting or whatever, but they said, hey, if you're distracted, it doesn't matter why, right, we'll pull you over. Anyway. So the states have the power to regulate in those areas. And then there's the Dormant Commerce Clause, which must be on the next slide. There it is. Basically, it's the Supreme Court's interpretation of the Commerce Clause that said, yes, the Constitution clearly reserves the right to regulate interstate commerce to the federal government only, but the states, we're going to let them regulate as long as they don't go too far. Because it really, really is hard to regulate in an area that doesn't have any impact on interstate commerce. Like one a while back ago was mail order wine, or ordering wine over the internet and having it delivered to your door. Michigan was all like, we don't know who's going to get the wine, which I guess makes sense. I mean, our UPS person, they whip the package from wherever they're standing on the road. They don't ID us. So I think, what? Oh man, well whoever works our route, they're not IDing me.
They didn't ID my sister when we ordered it. I think they eyeball it, but my sister's 15, so I'm pretty sure y'all do a bad job. I was helping in Christmas.
Uh-oh, fight. Yeah. your mileage may vary. How about that?
Some drivers just don't care, but some, like one I drove,
Yeah.
I had to, because I...
Right. Should I use a different name? FedEx? There you go. FedEx drivers are horrible that way. So, anyway. The Supremacy Clause reinforces what we were saying earlier in terms of the U.S. Constitution being the supreme law of the land. There are some areas where there's really concurrent power. Both the feds and states are regulating in it. However, if it's an area that the federal government can regulate in, and there's a conflict with a state, who wins? The feds do. If the Constitution gives them the power, then they could preempt state law. They win. The feds win in that situation. All right, so there's the Bill of Rights, originally applied to the federal government and applies to the state now, and then we're going to look at how the Bill of Rights impacts business. And, we talked about some of those rights that we have. For example, we mentioned free speech. All of these rights are not absolute. Like you might think you have the right to speak freely, but only under certain circumstances, right? Try joking about bombs when you're standing at the line at the airport and then saying, I can speak freely. No, there's a statute against that, right? But it's more than what you say. It also could be what you're wearing. It could be what you gesture. Yeah, I see you out of the corner of my eye. I mean, it could be those things that aren't actual speech, but are symbolic. That was the case that somebody asked me about in the last class, Hodgkins. That is a curfew case. And the other case, Texas v. Johnson, is the burning flag case. So is burning a United States flag speech, or is that beyond the scope of constitutional protection? So those kind of questions come up. Now, in terms of individual speech, we said that we don't have an absolute right, but if the government interferes with our right to speak freely, it's suspect. And then they've got to come up with a good reason why they're doing it. Businesses, a little different. First of all, businesses have a right to speak freely. They are also protected under the Constitution. But their right to speak freely is more restricted than individual speech. I don't know. I don't know what signal we have yet, but wink, something. Did you all hear that, or were you? So the government can regulate commercial speech. The government can regulate individual speech. Corporate or commercial speech is more regulated, more restricted than individual speech. And when we talk about corporation speak, obviously buildings don't talk. We're talking about politically what they say and what they say through their advertising. So there's restrictions on what companies can contribute. Then that goes back and forwards. Or there's restrictions on what you can say in your advertising. Like, anybody here yesterday that the iPhone's coming out on Verizon? That was big news yesterday. I've been waiting for that. But they're going to start trashing each other. I mean, it's going to be an all-out, your mom's ugly type thing, because they've already started. Like your network's slow. So anyway, so can they say anything they want about themselves or their competitors? No, there needs to be some restrictions on it, because some of the things they say about their own product, if they're not honest, might be harmful to consumers. Here's the test. If you were highlighting or writing anything down, the government can restrict commercial speech, but if they do, the courts will subject it to this three-part test up here, those three bullets. In other words, somebody goes to court and they argue the government has restricted our corporate speech by a law that they passed or something they did to us, and we want you to say they can't do it. And the court says, well, let's look at these three factors. And I'll use it applying the Bad Frog case there. Bad Frog was a beer made in Michigan. It was bad. The frog was bad because he had his middle finger up on the beer, which beside the fact that frogs don't actually have middle fingers, let's say they do. That was their whole marketing thing. You see how far that went. But they wanted to branch into New York. And the New York State Liquor Authority says, we don't want your Bad Frog here. We got kids. They don't like to see obscene things. So we're not going to let you bring your beer here. Or if you do, it can't have that label on it. Well, the company is like, that's us. That's our market. That's our thing. And if the frog doesn't have his middle finger up, then it's like Friendly Frog. We're not Friendly Frog beer, right? So they go to court. They challenge the state liquor authority's governmental action to restrict speech, and the court applies this three-part test. First of all, is it a substantial governmental interest to protect children from seeing obscene things? Most people will say yes to that one. Okay, well, we're going to get there. 2, does it directly advance that interest? That's where people start going, I don't think so. Kids see a lot worse than a frog with its finger up. But I'll even give you that one. But the last one says, and must go no further to accomplish. Usually, another hint for you, if you see a situation where the government is outright banning something, then if there's anything that they could do short of that, they should. So what else could you do besides ban the frog if you wanted to keep kids from seeing it? Well, then isn't that a ban? Like if there's a big blue dot on there? Right. Put like my online students this morning said, you don't see beer in a toy aisle. Although that would be convenient. So I mean, yeah, put it someplace kids aren't. Put it up somewhere where they can't see it. Wrap it in something they can't see. Well, don't sell it in the bar. You know, why? Yeah, exactly. Why have kids in the bar? You should be able to sell Bad Frog beer in the bar because kids shouldn't be there seeing it. Or my favorite, when I was in Kalamazoo, they came out with a family video by us. I'm like, awesome. I take the whole family down there. We're looking at videos, and my son's like, how come all those men are going in the back room there? They all have to go to the bathroom. I don't know. But, you know, there's a sign on the door that says you got to be this age to go back here. Don't go back here. That was a way of keeping kids from seeing what was on the videos. Then shortly after that, they must have got rid of the room because stuff was all over the place. And then I quit I haven't taken my kids into a video store in years because the stuff that's out on the shelf is nasty. Anyway, so they failed the last part of the test because there's got to be other things you can do besides banning a product. Now, sometimes there's not. Like there's certain things you can't market to kids, right? You know, what happened to Joe? Yeah, what happened to Joe Camel? Right? So people have their theories on that, but somebody showed me a while ago a video of the Flintstones smoking. Like if you go back to the original Flintstones, you guys heard of the Flintstones? Yeah. So Fred and Barney are beside a rock during the break at the rock quarry, and they're smoking cigarettes in the cartoon. And Fred goes, "Try," and I forget. Anybody remember the brand? Anybody seen that YouTube video? It's on YouTube. You know, he raises a pack of Marlboro Lights or whatever it is. They weren't light back then, and says, "Boy, I just enjoy a nice smoke while the women do all the work," or something. It's a very politically incorrect video. But yeah, they had to quit using cartoons to market cigarettes. That was bad. All right, so here are some things that are not protected. You can't defame somebody. You can't say something about somebody that's not true to harm them. That's not protected speech. You can't threaten to bomb some place. I had that when I was a prosecutor one time when Columbine happened. And then a bunch of students were running around in trench coats in class. You guys probably don't remember that. Maybe you do. But I prosecuted a number of juveniles who were threatening to bomb the school because they didn't want to take a test or they were angry about something. And the defense attorney inevitably said, well, they were just mad. They're speaking freely. They should be able to say what they want. People didn't have a sense of humor about that. Fighting words, inciting riots, screaming fire in a crowded theater. Obscene speech is not protected. A lot of people don't know that. That, if I give you a scenario, like the cussing canoeist case. Guy's in a canoe and flips out, starts cussing, and he does it in front of woman, child, apparently off-duty officer or something, and then he's prosecuted under a 100-plus-year-old statute that says you can't swear in front of women and children. Right? And he argues free speech. No, because there's no constitutional protection against spouting obscenity. Instead, he argued equal protection. Why is it that women can swear in front of men, but men can't swear in front of women? He won that part of the case. Still, the judge felt like you shouldn't swear in front of kids, but turned out the legislative history said the reason they had the statute was that more than 100 years ago, if you swore in front of a woman, they believed she would pass out. So the judge determined that wasn't a compelling governmental interest and said, no, I don't think so. All right, and then the same thing online. There's been several attempts to create laws to restrict speech. Remember, obscene speech isn't protected, but to prevent kids largely from being victimized or seeing things. And honestly, there's a lot of things you can see, say, do on the internet you couldn't come in here and do, right? I mean, if you go out there and look, just turn Safe Search off on Google. Don't do that. I'm not advising you to do that. I'm just saying you could search for any innocent term and stuff will come up that you won't see in this classroom. Or you could say something that's hateful. It's difficult to police the internet. Like one of those laws, Children's Internet Protection Act, one of them talked about, one of them had to do with filters in libraries, what you'd filter and whose content should be filtered. Another one had to do with, let's say we create this law that says you can't depict children engaged in sexual acts on the internet. Everybody outside is like, well, wait a second, what's up in that class? How many of you think it's a good idea not to depict children engaged in sexual acts on the internet? Okay, good. Seeing whose hand's not going up. So everybody thought that was a good idea. Then somebody came along and said, well, I can use a computer to generate an image that looks like that, but it's not really that. But you can't tell it's not that. And the court said, oh, that's interfering with somebody's ability to be artistic. And said that the law was too restrictive because it would include that, when it really should only include the depiction of real children. Sorry. Mm-hmm.
Had been dismissed from the music over disputes of some sort. He, before he left, changed the label and had genitals on the label. It was distributed to stores.
Ouch.
Target had to pull like 150 cases of this because, and they weren't the only stores that got it. There were stores all over the country.
That's not good.
So, I mean, when you talk about that, yeah. And when it went to court, he cited the same thing.
Ability to be artistic and draw. Yeah. Well, I remember being in a training where police would get an AOL profile. This is back when AOL was popular. And they would go into a chat room. They'd say, hi, I'm Johnny. I'm 12. I like teddy bears. Right? And within seconds, some predator would come in. Of course, now they have To Catch a Predator. I mean, it's all the same thing. And this guy comes online and he says, hey, Johnny, I live right by you, and I like teddy bears too. I'll meet you at the park. I'll be driving this van. I'll be wearing this. I'll bring you a teddy bear. And I want to do this, this, and this to you. And because he doesn't know on the other end is 6'6" state trooper, right? So they arrange to meet, and everybody goes down to the park, and there he is, by the van, in the clothes, with the teddy bear. They arrest him. What do they arrest him for? He didn't. Can't get arrested for soliciting a fictional character. There was no little Johnny. So I guess my point is just sometimes it can be challenging to enforce things on the internet because there wasn't any little Johnny. So what else could he be charged with? Usually somebody will say like, well, he meant to do it. Right, you can't be convicted of intending something. I mean, somebody challenged me on that. Feeling spunky.
What if he had priors?
Does that mean you're guilty now?
I don't know. What if he was a sex offender and maybe he thought that he was making himself?
Well, under the Sex Offender Act, there might be something that requires him not to go on the internet, not to engage with children in any form or anything like that. So that might be a different story. But just because you intend to do something, like I'm intending to do something to you guys right now. It's really bad. Right. But you don't know what it is, right? You see Minority Report?
What about drugs, though? Like, they manufacture with intent to sell.
Yes. Because you actually manufacture it. You actually manufacture, and you do it in such a quantity that it actually demonstrates your intent to sell.
Maybe it was jealous that you could smoke so much.
Yeah.
You're right.
Like,
Yeah.
your house or whatever.
Yes.
And
Yeah. Those ones have been challenged. They're not always that successful, but there have been challenges under that act based on that with intent. I mean, any act that says with intent to do something, you have to establish circumstantially, unless the person says, yes, that's what I was doing. But if you come to the door, you knock on the door, you're undercover, and they sell you some stuff.
oh yeah.
You know, I mean, so I can see both sides to that. But all right, anyway. Back to online. It's difficult sometimes to establish things online. Freedom of religion. A lot of people think that the Constitution says there has to be separation of church and state. It doesn't actually say that. It's not there. You got a copy? Look it up. It doesn't say that. Instead, there's two clauses. One is the Establishment Clause, the idea that the government can't establish a religion. Now, when's the last time Obama says, here's the official religion? Yeah, probably. Yeah. No one's going to do that. But usually a lot of the cases are around how is the government acting, or what laws are being created in a way that gives preference to a religion, or establishes a religion over no religion, or something like that. Or how do we use buildings, or various things. Who gets funding? And then the second part is free exercise. You should be able to freely exercise your religion. The government should not interfere with that. Unless you interfere with someone else's constitutional rights. There's been a lot of cases about that too. My belief is, I'm not saying this is my belief, but as an example, no blood transfusion for children. I like to smoke peyote. There's been all those cases. And, is that a religion? Yes. Or I'm Rastafarian. So, let's see. Should I be able to do that if that's contrary to some statute that's out there? Those are tough ones. All right. I think we got most of that. Due process. So, due process has to do with fairness. We were talking about fairness earlier. For example, under the Constitution, the government has the right to take your private property for public use if they give you just compensation. But the question is, how does that happen? If they just show up with guns one day, that's not due process. That's not what's fair. What they're supposed to do is let you know they want to do that. and then I have a hearing to determine if their purpose is public, and then finally, if they end up taking your property, whether you get just compensation or not. And you should be able to be there, and you should be able to say something, and whoever decides your case should be impartial. Often, the amount of evidence or the burden the government has to meet relates to how important the right is, like whether it's a fundamental right or whether it's a non-fundamental right. What's a fundamental right? Anybody find that in your chapter? That's in the Constitution. I don't know if there's any real guarantee about happiness, but if you look in there in your chapter, it talks about fundamental rights, like all the First Amendment rights and the rights we've been talking about. If the government interferes with that, there's really kind of presumption the government has a problem, and unless they can show a compelling reason for that, they shouldn't be able to do it. For example, discrimination based on race. There's not a compelling reason to discriminate based on race, so that would be automatically presumed to be something that's unconstitutional. If it's a non-fundamental right, then just the government has to show a rational relationship between what they're doing and what their purpose is and what they actually did or what the law was.
So does that make the death penalty unconstitutional?
Well, yeah, back up to the top. Notice it says life, liberty, or property. The Constitution doesn't say the government can't take your life, liberty, or property. It just says they can do all those things. They just have to do it fairly. Paraphrasing here, it says they can put you away forever, kill you, or take all your stuff as long as they do it fairly.
So they can't shoot you in the face because that's not fair.
They could kill you, but to just shoot you in the face might be cruel, unusual, unfair, right? So the way they do it, the process they take to do that. Right? States may feel different about that. That's why there's a federal death penalty, but Michigan doesn't have one. All right, equal protection. The law doesn't say that everybody in the United States should be treated exactly the same. The courts have determined that what the Constitution means is people who are similarly situated should be treated the same. The easy example I can think of is two people are charged with a crime. They're convicted, and they're being sentenced. What might impact how much time they do, if any? Right, their prior record. And if they're not similarly situated, one's had a long history, one is the first offense, they may not get treated the same. And then at the bottom it talks about these 3 levels of scrutiny. What page is that on? Because I think this is kind of a tough one. 25? Make a note of that. We were talking about a little earlier in terms of whether it's a fundamental right or it's something that's non-fundamental or some economic interest. Let me give you, what does it say, when do you apply the intermediate scrutiny test? It says there, in number 2 there. It's a harder standard. Courts apply it when it relates to gender or legitimacy, meaning whether your mom and dad were married when they had you. So, gender. Remember that example of the cussing canoeist I gave? You know, the argument that it's discriminatory to prevent men from swearing in front of women. The court would apply the intermediate scrutiny test. And the test says the government has to show what? That's also in italics. So it goes from, it talks about compelling, important, legitimate, right? So look at those different levels. If it's something like race, fundamental rights, strict scrutiny. They better have a compelling reason to do it, or it's automatically presumed to be, let's say, here's another example. Let's say I want to have a hot dog stand downtown, and then the city won't grant me a license to have a hot dog stand. They're discriminating against me. They are, because they didn't give me a license they gave other people. What kind of discrimination is that? I haven't told you anything that says it's gender, right, or race, or anything else. It's purely economic. Maybe they say, we got enough vendors downtown, maybe safety, whatever. All they have to do is show some rational reason. I think that's what it says, rational reason for doing what they do. And that's pretty easy for the government to do.
So then this biker thing that they're talking about having here downtown,
Mm-hmm.
there are some restaurants and small businesses that are opposed to that and are fighting it, but if the council approves that they could do that in July, those vendors possibly could be brought to court.
Yeah, I wouldn't offer an opinion as to what rights the bikers or the business owners have downtown, but
Council and these business owners right now.
right. Well, I mean, the first question as we go through that is, are we talking about a governmental action? If we're talking about, some governmental entity making a decision, then some people who feel their constitutional rights are interfered with could argue that they were discriminated against because they didn't get to assemble or whatever it is that they're saying they get to do. Then we'd figure out which test applies and then figure out whether that governmental, whatever it was, had the important enough reason to do it. And that's what courts decide. All right, and then finally, privacy. The right to privacy is not specifically mentioned in the Constitution. You'll see that one coming up. Instead, it's implied. Like, would we have a right against unreasonable searches and seizures in the Constitution if the framers of the Constitution didn't think there were some areas that were private? So the Supreme Court has said, based on the protections that are in the Constitution, the constitutional framers intended for there to be a right to privacy. And that implies in every area where there's an expectation of privacy. Not yours. Like you might expect you have privacy in your desk at work or the email you sent out from work. No. But what is reasonably an expectation of privacy? Your homes? Yes. Your car? Some places. Right? But a public place or work email? Not so much. All right. And then a number of these acts, these federal statutory protections, end up relating to privacy.